and you can talk until they come in. I'll tell you when they're there and ready, all right? And then you'll be talking into that microphone.
Yep.
And reading that line. So easy peasy lemon squeezy.
Are admonished to draw nigh and give their attention to the court.
Now sitting. Go ahead.
Now setting.
Please be seated. Good evening. We welcome all of you. It's so good to have such a nice crowd this evening. I'm Chief Justice Marla Lukert, and it's my pleasure to welcome you to this special session of the Kansas Supreme Court. We are very excited to be in Louisburg. I've been here for 2 days and have had an incredibly warm welcome. I appreciate the outreach from the community. We are excited this evening to be able to provide you an opportunity to watch the court in action and give you a chance to meet the justices during a reception that will follow the oral argument. Tonight is a continuation of an effort to make the Supreme Court accessible to the people of Kansas. We have turned to the Beach Boys to provide our Supreme Court Road theme song. We round, round, get around. So 2 times a year, we leave Topeka and we visit a Kansas community to show Kansans how our court works. All our hearings are public, so anybody can hear and come into our courtroom and listen to any hearing we do. But few Kansans can take the time to get off work or school or all of the other life demands that might interfere in being able to come to Topeka to watch a hearing. We also provide live streaming of our hearings, and there are web archives of our hearings on our YouTube channel. But that's different than being here in person and really getting to experience it and then meet with us and ask us questions afterwards. So here we are, getting around. We spent the day visiting schools throughout the 6th Judicial District with local judges. The 6th Judicial District is one of 31 judicial districts in Kansas. The sixth is made up of the counties of Bourbon, Lynn, and Miami. The justices visited all 3 counties today to speak to a group that we would approximate of about 1,200 students. We hope the students learn more about how courts work and also about career opportunities in the law and in the court system. The students we visited attend Louisburg, Prairie View, Osawatomie, Paola, Pleasanton, Fort Scott, and Jayhawk Lynn High Schools. We want to thank all of those schools for giving us the opportunity to visit with their students and for their hospitality and opening their doors for us. This evening, as we have said, you will have the chance to see firsthand an actual case, and you will get to see who we are, what we do, and how we do it. We are very delighted that you are taking time to learn more about the court. I would like to introduce my colleagues who come from all over the state, really. I will mention that I grew up in the very far northwest corner of Kansas in Goodland. Eric Rosen hails from Topeka. Dan Biles grew up in El Dorado. Caleb Stiegel in Lawrence. Evelyn Wilson in Smith County. I thought for a second I skipped somebody, but I think I'm on track. Justice Wall in Scott City and Justice Standridge in Lawrence. I didn't leave anybody out, did I? Oh, good. But before the clerk calls our docket, I do want to take a few more minutes to express my gratitude to all of those who helped make this evening and today possible. I will first shout out to the court administrators. Some of them may be in the crowd. Some of them still may be in the hallways helping out there. The administrators, the teachers, the staff of the high school have been incredible to work with, and we're very appreciative of all they've done. I also want to thank the judges of the 6th Judicial District. As I mentioned, they visited schools with us today, and that was a big help. Chief Judge Amy Harth has taken on a special load of helping us organize tonight. We also want to thank all of the employees of the 6th Judicial District. We thank them not only for doing things to help with this event tonight, but also for all they do each day to help serve those who are in their counties, the citizens of their counties. Another group who has helped with activities tonight, you probably have seen the law enforcement presence and the security personnel that are here. So Louisburg Police Department, the Miami County EMS, and the Miami County Sheriff's Office have been particularly helpful for this event especially. We do have others who regularly help us when we do events like this, including the Highway Patrol and the Capitol Police Protective Services and Kansas KC Protective Services as well. So we thank all of them. And the final group I do want to thank is our own staff, including our Clerk of our Appellate Court, Mr. Doug Shima, who you'll meet again in just a minute, the staff of our Office of Judicial Administration. The logistics of this, as you can imagine, do take quite a bit of planning. And last, I want to thank one more person and recognize him, and that is our honorary bailiff for tonight's docket, Sherman or Wes Cole. Mr. Cole has served our state through his work with the Governor's Behavioral Health Services Planning Council, his employment and leadership at the Osawatomie State Hospital, and in so many more ways that I don't have time to mention tonight. He has also helped at the local level through his community of Osawatomie and his public service as a mayor, a city manager, a city council member, and through countless volunteer activities. Mr. Cole, thank you for your volunteerism. Thank you for the contributions you've made to our state. I know you have advanced us in the area of behavioral health sciences enormously, and we are very honored to have you opening court for us this evening. So thank you. So just a little more about tonight's work. As you've heard, this court proceeding is what we refer to as oral arguments. So attorneys will, in just a couple of minutes now, will present legal issues to us to support their clients' positions. One party will argue first. This is the party who has not succeeded in the court below, at the district court level, the trial court level, and then that it was appealed to the Court of Appeals, the intermediate court. One of my colleagues likes to refer to this as thinking of the trial court as the officials that are on the football field, calling the game calling the penalties at the time of the game in the split second that it's happening. And then thinking of the appellate courts as those replay officials that are sitting in New York. That's us, and we have that opportunity to take time to look back at the full record and to replay things and to take time in making that decision. The other party, in this case the state, will respond to those arguments, and then it will refer back to counsel for the defendant in this case to give the closing rebuttal argument. These attorneys will ask us, or will argue to us why they believe we should accept their legal positions. This interaction helps us in our duty to enforce the rule of law and to make decisions that the law requires. The parties have presented to us written briefs, and they cite to us legal authorities, including in this case, the United States and the Kansas constitutions, and statutes. We will be focusing on statutes passed by our legislature, and also law that is made through court decisions. That law frames the decisions that we will make in this appeal. We don't evaluate when we look at a statute whether it is good policy. That is the job for the legislature. Our obligation is to set aside politics, special interests, and even public opinion. That means, for example, that we are not going to end the night by taking a poll and a public opinion survey and ask you how you think we should decide this case. We must remove ourselves from those influences because our job is to maintain fair and impartial courts for all Kansans. As Thomas Jefferson said 200 years ago, the most sacred of the duties of a government is to do equal and impartial justice for all its citizens. We hope you leave this evening with a better understanding of the contributions of the lawyers and judges in furthering the rule of law and the role of fair and impartial courts. The last thing I will mention to you is that you notice we have papers, we have computers sitting in front of us. You will see us looking at those as we consult the notes we have made in preparation for tonight. We may be checking a brief, we may be consulting notes we have made, we may be checking a case or a statute. We do this to assist ourselves in understanding and processing the arguments, but we want to assure you that when we do so, we are listening as we do that. So with all of that, I thank you again for being here tonight and ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call this evening's case.
Thank you, Your Honor. May it please the court. The 6:30 p.m. docket for Tuesday, November 12, 2024, consists of one case, appeal number 126350, State of Kansas versus Brian Beck, Geary County, briefs both sides. Attorneys will enter their appearance.
May it please the court, Brian Beck appears through counsel Casper Shire, Kansas Appellate Defender, present and ready for argument. And Chief Justice, could I please request 3 minutes for rebuttal?
3 minutes for rebuttal is granted. Thank you.
Thank you, Your Honor.
On behalf of the appellee, the State of Kansas, Ethan Ziff-Sigler, Assistant Solicitor General, present and ready for argument.
Thank you. Thank you, counsel.
Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Mr. Shire, you may approach the lectern, and you can proceed with your argument when you are ready.
Thank you, Your Honor. And again, my name is Casper Shire, appearing for Brian Beck. When I got here around 5:30 tonight, I took a lap around the parking lot looking for license plate frames. And I counted about a dozen of them at 5:30. This auditorium has filled in a fair bit since then, so I feel pretty confident in saying that we've got another couple of dozen out there in the parking lot right now. They're not all the same. Some of them are put on there by car dealerships. Some of them celebrate Kansas City's recent Super Bowl victory. and some of them don't say anything at all. They're just there to help secure a license plate to a car. Brian Beck had a plate similar to the ones that to those plates out in the parking lot tonight when he was driving down I-70 through Geary County near Junction City. Brian's license plate frame covered up the top half of the word Illinois on his Illinois license plate, and law enforcement pulled him over solely because of that license plate frame. When they did that, they called his plate number into dispatch, identifying it as an Illinois license plate from a squad car before making contact with Brian. And the primary question before this court here tonight is whether that traffic stop was lawful at its outset. License plate frames like Brian, and like the dozens in the parking lot here tonight, do not violate Kansas law so long as the plate within the frame remains clearly legible. And Brian's plate was. When no law has been violated, when no traffic law has been violated, the Fourth Amendment does not allow for suspicionless seizures. Brian's license plate did not justify pulling him off the highway, did not justify detaining him to write a warning citation, did not justify keeping him detained to run a drug dog around his car, and did not justify the ultimate search that turned up drugs. The district court in this case erred by denying Brian's motion to suppress. The Court of Appeals erred by affirming. And we are asking this court tonight to reverse both of those decisions and send this case back to district court with instructions to suppress all fruit of this unlawful seizure.
Are you asking us to apply a different test to determine kind of the clearly legible or free of foreign material that prevents it from being clearly legible? Or is there a different test you want us to apply?
The test that the district court applied to this question, Your Honor, was whether or not the plate would be clearly legible to an officer at a safe following distance. And we are asking this court to say that's the wrong standard. And that's the wrong standard because the language by an officer at a safe following distance is not in the statute. The statute requires the license plate shall be fastened in a place and position to be clearly visible and shall be maintained free from foreign materials and in a condition to be clearly legible. It says nothing about an officer at a safe following distance.
So if we do that and we talk, we don't implicitly find language in the statute saying at a reasonable distance, well, I guess it would be the other way around. Would it be possible for the officer at a reasonable distance not to be able to see that it's legible and then pull them over and walk up to the plate and see it is legible without, and then telling the driver, I didn't believe that your plate was legible, now I do. Just that initial brief contact, don't ask for any identification, and then the officer goes back to the car?
Yes, that would be, I didn't mean to cut you off, Your Honor.
No, I'm sorry.
Yes, that would be entirely possible, and in fact, that's what our case law says should happen. I would point to Diaz-Ruiz, which is a case where an officer saw a ladder on the back of a truck, I assume, thought it looked loose, stopped the car, went up, gave it a tug, confirmed that it was secure, and then used that as a platform to launch into a drug investigation. And that is not what should happen. What should happen is exactly what you said. I thought I saw a statutory violation. Now I see that it's not. Thank you for stopping. Be on your way.
But in that circumstance, if the officer sees something in plain view, would that spur reasonable suspicion or probable cause?
It could, Your Honor, but that is not this case. Here, law enforcement did not have reasonable suspicion of potential contraband until they ran a drug dog around the car, and that was after Mr. Beck had been detained in law enforcement vehicle for several minutes, waiting for a warning citation to be written. So that's possible, but not here, Your Honor.
What's the term? I don't really care what the case law has tried to do with this statute. I mean, it's been around for, you know, what?
1929.
Yeah, 90 years, 95 years. And
1939, maybe.
yeah, and then there's a lot of different case law that to me looks conflicting or tries to embed a purpose to the statute. And, you know, I know we used to do that a long time ago, but we pay attention to text. So the term, it seems to me, the operative term is clearly legible.
I agree, Your Honor.
What's that mean?
It means, can you see it? Or excuse me, can you read it?
Well, I mean, if I go to the dictionary, which I did, it's, you know, clearly, easily equates, and then legible equates with decipher. So just, is it easily decipherable?
Yes, Your Honor.
So how does that, how are we able to apply that term? I'm really struck by how arbitrary the enforcement aspect of just that term, just the statutory term, whether we can save the statute or not, because clearly legible seems to be in the eye of the beholder.
And I appreciate your concerns. It is absolutely something of a slippery fish. And I think a good comparison is, you know, we talk about the difference between battery and aggravated battery being great bodily harm. Well, what is great bodily harm? Again, that's largely in the eye of the beholder, and two different fact finders can potentially look at the same set of facts and come to different conclusions.
So, I'm sorry, I'll let you go ahead and finish. I couldn't tell if you were...
No, what I was going to say, Your Honor, is that the real problem we have here is, as you suggested earlier, Justice Biles, the district court is injecting something more into the standard it applied, which is clearly legible to an officer at a safe following distance, which at highway speeds is something like 300 feet. And that's, no plate is legible at 300 feet. It simply cannot mean that.
So, following up on that, if we agree that the plain meaning of the words in the statute is understandable,
yes.
Like you mentioned, great bodily harm, for example, but it's a plain meaning that is, as has been said, perhaps in the eye of the beholder. Typically, we call those fact questions, and you even referenced fact finders. Is that what this case is about, fact finding? Because the district court did make fact findings. Are you arguing that those fact findings were made under an erroneous standard, or just that the evidence does not support the finding?
I'm arguing that the district court applied the wrong standard, and also that if the district court had applied the correct standard, which is just legibility, full stop, is it readable? There's only one conclusion to draw from.
Let me inquire into that, because as I read the transcript, the officer testified that he could not read the name of the state. Even when he walked up to the car, he could not read it. And wouldn't that be at least some evidence that the plate was not clearly legible under whatever standard you choose to apply?
At the end of the day, Your Honor, I think the photos, the exhibits, speak for themselves.
Well, then are we reweighing evidence? That's my question. If an officer testifies, I walked up to the plate and could not read the name of the state, now we're in fact world, we're in weighing evidence, and if a district court believes that and gives it more weight than the photographs, what are we to do? And what are you to do as the advocate?
Sure.
Arguing against that holding?
Sure. And I guess at the end of the day, Your Honor, I don't think whether an officer testifies subjectively that he can read it or that he can't read it is dispositive of the outcome. I think the question is legibility. This particular officer said that he couldn't read this plate, but we have a picture of it.
So is your argument then that when there's a photograph or video evidence that, I mean, it can't be the rule that testimony falls by the wayside when we have a photograph? I'm just wondering if you might be backed into the corner, essentially, of arguing the weight of the evidence.
I guess what I'm arguing at the end of the day, Your Honor, is that at minimum, this would need to go back for the district court to apply the right standard, at minimum.
So just for example, as I take what you just said, you're asking us at a minimum to articulate that the from a distance rule is not part of the statute.
Yes.
And if that tainted the district court's evidentiary findings, it really needs to have a do-over.
I think at minimum that needs to happen, Your Honor. I would further argue, though, that in this case, based on the evidentiary record we've got, any conclusion that this tag was not legible is not supported by competent evidence. And if that's, I think ultimately if this court agrees with that argument, there's very little purpose in sending it back with anything other than orders to suppress.
Well, we know the officer was able to read the plate.
We do.
From his car.
Yes, Your Honor.
12 feet behind after pulling it over.
Yes, Your Honor.
What do we mean by read the plate?
Call it into dispatch to run the plate.
The numbers and the letters, is that what you're referring to, that he was able to?
The numbers and the letters, he did identify it as an Illinois plate at that time.
I take it you're not, so as I read the testimony, the officer testified that he was able to identify it as an Illinois plate due to the distinctive nature of the plate as opposed to reading the name.
That's right, that was his testimony.
So would you suggest then that clearly legible under the statute requires objective proof as opposed to the subjective view of the officers?
Yes.
Okay, so that's your argument as to how we're not necessarily bound by one person's perspective, but would an objectively reasonable officer have been able to read or discern that it was a legible plate?
Yes, Your Honor. And at the end of the day, the bottom half of the word Illinois, particularly in the context of a license plate where we know there's a very small universe of words that might be there in the first place, can only be Illinois.
Does it matter?
And can I follow up with one more question? When we're analyzing what is plainly legible and when we're examining a license plate, we necessarily have to know from what perspective, right? I mean, is it 100 miles away? Is it 100 yards away? Is it 6 feet away? The statute doesn't tell us that.
No.
Is it ambiguous then? And then we have to resort to our own interpretation of from what perspective we have to determine legibility?
No, Your Honor, I don't think it's ambiguous. For example, if you picked up one of those statute books behind me and held me up and asked me to read it, I would not be able to. That's not because the book isn't legible. It's just because I'm not in a position where it being legible helps me at all. I need to get closer to see it. The book is legible even if I'm 100 miles away. I can't read it, but it's still legible.
What do we do in the circumstance if distance, I assume you're arguing distance is not a factor in applying the statute?
Yes.
That's what you're saying, but let's say it's a common experience that when you're on a dirt road, a muddy road, license plate will become not clearly legible, only from a few inches or a few feet. What about that instance? When it literally takes to be a couple of inches away to discern its legibility? it's clearly legible at a certain distance, but that's what it takes. Does that fit in your test?
Well, I can't give you a distance because there is no distance in the statute, Your Honor.
Okay.
If the statute writers could have set a distance, and they didn't. They made the test legibility. And if it's legible, if I can get up to it and read it, then it passes the statutory test.
I'm struck by the language of the statute. It seems to me where courts get distracted from the language of the statute. By that I mean they worry about in this case, the name Illinois being partially obstructed at the top. But the statute doesn't talk about legibility of the letters. It talks about the plate itself. And so when a law enforcement officer says, I can decipher based on what I could see, I could decipher the plate being an Illinois plate, I don't see why it matters that there may be some letters that are blocked off. It was clearly, the plate itself was clearly legible. And do you have any case law that comes to mind that talks about the plate itself as opposed to the lettering or the numbering or that kind of thing? I was trying to come up with one and I didn't see it.
A case that deals with lettering on the plate,
It's
besides
being able
the
to
state name.
decipher the plate, the design of the plate, because these plates are all kinds of designs if you look across 50 states, or even look in our state, and sometimes you have Jayhawks and Wildcats and Pet Friendly and that kind of, there's all kinds of designs here. But the statute talks about the plate, so should we really focus, I guess, on the plate itself as opposed to just the lettering?
Yeah, and I guess the only case that really jumps immediately to mind is the 1983 Hayes case, which was a Court of Appeals case. That was a case where the officer pulled over, I think that was an Indiana tag, and the tag was fully obscured, right? The state name was fully obscured, but there was a motto on there that the Hoosier state, that the officer didn't know.
Didn't know what Hoosier meant.
What's that?
The officer testified that he or she didn't know that Hoosier meant Indiana, right?
Right, that's right, Your Honor. And that was, I guess, the Hayes court got into, well, one of the primary purposes is to identify where this plate is from, and, without a state name, we can't do that. Now, that was a fully obscured state name, not a partially obscured state name, and I think that makes a big difference. But the other thing I'll point to is cross-examination in this very case. One of the questions the defense attorney asked was, well, what about Land of Lincoln at the bottom of the plate? Is that something you would have pulled him over for? And the officer said no. So that's an indication that at least in cases like this, it's not any obstruction of any part of the plate that makes it a violation. I think it has to go back to legibility and, the ability to figure out where this plate comes from and what the numbers on it are.
We are required by statute to affix a small tag, about an inch and a half, in the corner of our plates, and that's part of the plate, which is something that is legible only at a near vision. Can we discern anything from that as to what the intent is about legibility?
I think potentially we could, Your Honor, because that's obviously very important information on the plate. You don't know until you get up to and read the sticker whether the plate is still valid or not. And there's no way to know that information until you get very close.
Well, isn't it Don't they issue a new color every time?
They do issue a new color every year.
So you just have to look at the color? Oh, but you'd have to read what month it
You
was.
still have to read what month it is,
Right.
Your Honor.
And it still has to match the plate number that's on there, because you could, some people have been known to put the wrong sticker on a tag, on a plate like that, and then it doesn't match. So you have to be able to see that as well.
Yes, I think that's all right. I think this court might be pushing my knowledge of license plate compliance, but that all sounds right to me.
I want to ask two questions to kind of narrow and make sure I know for sure what's being not before us. So the statute has three requirements. Clearly visible, and I don't think that's disputed, but it also says shall be maintained free from foreign materials. And then the third is the clearly legible that we've spent our time tonight discussing. There have been no arguments about whether this violated the statute because of a foreign material?
That was certainly not what the district, that's not what the district court found. The district court found that it was not clearly legible, and I do not remember the question of foreign materials coming up either in the district court or in the briefing.
But the panel did conclude that it was not visible either, correct?
The Court of Appeals panel did conclude that it was not visible, Your Honor, and it's our position that that is just plain wrong.
Because it doesn't give unique meaning to the term visible?
Visible means can you see it?
Yes.
And you can absolutely see this plate.
And then as to your vagueness argument, as I understood your briefing, you're really arguing only that if we read in the distance language that's been adopted by a Court of Appeals panel, that's what creates it to be vague. But that if we just read the words of the statute, that clear visibility you're not arguing is vague. Is that true?
That's absolutely right, Your Honor.
Are there other questions? Okay, thank you, Mr. Shar.
Thank you, Your Honor.
May it please the court, on behalf of the people of the state of Kansas, Ethan Ziff Ziegler, Assistant Solicitor General. What makes this case interesting to me, because I am a weird legal nerd, is the procedural posture of the case. When this case first went up on appeal, both Mr. Beck and the state made arguments about the license plate needing to be visible from a safe driving distance, because that's what the district court found, and then that led to a constitutional argument. But when the Court of Appeals made its decision, it just said, look, we don't even need to consider all of this extra language that the two of you go back and forth about. The only question is whether it's clearly legible and clearly visible. And under the definition of clearly legible and clearly visible, it is not those things. It is not clearly legible because the officer never read the plate. The officer identified the plate because he recognized at some point the pattern of the plate and realized it was an Illinois plate, but he never read it.
So let me jump in there, and what occurs to me when I read this is we might be focusing on the wrong part of the statute. Instead of clearly legible, what I want to know, or the question that occurred to me is, what is a license plate? Because, I mean, you used the pronoun it. It was not clearly legible. Is the name of the state part of the it? Would you agree that there's no law that requires that a license plate have the name of the state stamped on it?
I actually don't know the answer to that.
I mean, assume with me for a second that that is the state of the law, that the name of the issuing state is required to be on the registration decal or an abbreviation, but there is no requirement that a license plate include a state name.
If that were true, I would still argue that the name of the state and the issuing state would be part of the license plate.
Why?
Because that is part of the identification. In states when we all used to have 6-digit codes, there could be two states that had issued the same 6-digit code.
So if Illinois had didn't include the name Illinois on their license plate, how would that be any different than a partially obscured word Illinois?
I think it would be about how, that is a good question. It would be about how you were able to identify it. Like, what are you reading on the statute?
Well, let's go to
license plate.
the example your opposing counsel raised about the land of Lincoln. Is that part of the license plate? In other words, if the land of Lincoln is obscured, does that violate the statute?
I don't know the answer to that. I don't think it probably would if Illinois is clearly visible, but I think a state motto is not the same thing because it's not necessarily that you're going to be able to identify.
Does your argument require that does your argument fall or fail if there's no requirement in the law that the plate have the name of the state on it?
No, because the argument is still going to be that it has to be clearly decipherable, something that is, and it's...
But I circle back to it. The question is, what is the it?
The license plate. The identification of your car through the license plate has to be clearly decipherable. And it's modified.
The statute doesn't say that.
Well,
that's the problem. It says the license plate has to be clearly legible. Right. And there's all kinds of, I think the point here is that there's all kinds of things on the plate. And so all of those things would have to be legible, including land of Lincoln or whatever the land of the Hoosiers or whatever phrasing the state happened to put on its plate. Anything that's on that plate's got to be legible just reading the statute. I can't help but think that the state is adding words to a statute, which we don't get to do, right?
I don't believe that I'm adding words to the statute. The word legible is modified by clearly, and clearly has its own definition. It means easily.
But what has to be legible? The statute says the plate has to be legible, not the numbering, not the identifying characteristics of the plate. It doesn't say any of that. It says the plate. And that's what we're stuck with.
Well, and I think then I would go back to the original argument in the state's brief, which is that the statute, reading it that way, if you don't have to be able to identify the statute, or the plate, I'm sorry, if you don't have to be able to identify the plate and be able to see what it means, then the statute is meaningless, because why have a plate at all if it doesn't mean anything? The plate is there to identify a vehicle uniquely.
Is there any evidence in the transcript or in the record that we have where an officer or anyone else said, you must have the state on the plate in order to identify the vehicle?
Not in this case, no, I don't believe so. I just go back to the state has to be part of the license plate because it is how you identify what the code means.
How do you know?
Because multiple states can have the same code, especially under the old coding styles where it was only 6 digits.
Where is it in the record that it says that?
I don't believe it's in this record, but I think we go into what is common knowledge to all of us of how license plates work. We can use and draw from examples in our common experience. It doesn't necessarily need to be in the record if it's not specific to the case.
I might be able to help a little bit here. KSA 8-132 talks about the state name, which may be abbreviated, must be included on the registration decal, on the display of the year or years for which it is issued. So was there any evidence in the record below about whether or not from the decal on the plate, a reasonable officer or this officer could have identified that the plate was from Illinois?
I don't know if there was anything in the record, because
I didn't see it, so
I'm guessing there's not.
And if there's not, does that matter? It seems like it could matter, I guess is my question.
I think it could matter. I run into this issue of the district court made a decision based on finding that uniquely that the license plate was not clearly visible from a safe driving distance, and the only party that appealed that was Mr. Beck. So if I believe that the district court made an error in how it ruled, the state never cross-appealed. So I think if we're expanding the issues, I'm at a disadvantage because we had never asked a finding that the lower court made a mistake.
Let me follow up on a question that the Chief Justice asked your colleague. And she said the sticker that's in the corner that I just put on my car yesterday, so it has a different color every year, every 2 years or whatever it is, but it has a month. And the month is tiny, right? It's very tiny. Under your position, that would need to be clearly legible, correct?
I don't know because I'm not sure if the decal is governed by a different statute. The display of the decal itself may be governed by a different statute with different requirements than the plate as a whole. So without getting into that,
But if, okay, so.
I just don't feel like I'm qualified to answer that question right now because it has not come up as part of the case, so I'm not as researched.
But it is part of the case. Hypothetically, let's pretend that there isn't a separate statute about that being, the separate statute just talks about how it has to be on there, and that this is the statute that governs the license plate, which of course it's affixed to the license plate. Then would an officer need to be able to read that from, I mean, the officer would have to go right up to the plate and look at it. You have to be really close.
I think it would really depend on if it's obscured or not. I tend to be able to read them. From the officers I've worked with over the years, they tend to be able to read the month and the color almost immediately.
It's decipherable, and isn't that true here too? Decipherable, he may not have, and this is Justice Biles, he may not have been able to read, the top half of the Illinois, but it was decipherable, correct? He deciphered it from.
Well, decipherable is modified by one, the definition as clear or easily, and then in Kansas specifically, it must be clearly. And the analogy I would give is, Friday is my favorite day of the week because that's when all of the Court of Appeals and Supreme Court opinions come out. If one day I'm looking at these opinions and on the front page, the top half of every line is obscured, it just didn't print correctly. I, from context clues and from the English language, can still read what is on that page, even though half of every single word on the entire page is covered.
It's decipherable.
It is, but it's not clearly decipherable. It is not legible.
So is it your position that every single thing on the license plate, including the little registration sticker in the corner, must be clearly legible?
If the sticker is part of the plate, which I do not know from if there's another statute that governs it, then yes, because the modification is that it must be clearly legible. So that means clearly decipherable.
So your position is that you violated that statute if pet-friendly isn't clearly legible, if Land of Lincoln isn't clearly legible, if To the Stars isn't clearly legible.
If it's not clearly discernible what the identification for the vehicle is.
Well, now you changed it to discernible.
Or sorry, if it's not clearly decipherable.
No, legible, clearly legible, every single thing on the plate. Nothing can be obscured.
But the definition that the Court of Appeals applied to legible was decipherable. Clearly or easily readable or decipherable is what they said. So just going on that dictionary definition that they applied, if the plate cannot be identified as what it is not decipherable.
That's not my question. Every single thing on the plate must be clearly decipherable, or you have violated the law. Is that your position?
My position would be I would rather it be that way than a way where it is in some way you can't identify who is in the car, or you can't make an identification of the car because it's not legible.
Well, if it is your position, what in the statute says that?
That the license, I would just say the plain language, that the license plate must be clearly legible.
Yeah, the Court of Appeals held that when half a word is covered, it is not clearly legible, no matter how close you get to it. That's their conclusion.
Correct.
And that then represents a violation of the statute. So it's the state's position that pretty much any dealership car frame, and I was doing the same thing Mr. Shire was doing probably for the last couple of weeks. There are a lot of frames that cover up half of the word Kansas, a lot. Anybody driving with that frame is subject to 6 months in jail. Is that where we're at with the state's position on this and this Court of Appeals decision?
I believe that's what the statute says. It is also a violation to drive with the little tiny light that illuminates your...
Well, I'm not talking about that. I'm talking about the license
right, I know.
frames that are issued by every car dealership around the country. As Mr. Shire pointed out, ceremonial types of world champions, Royals tags, K-State tags. Everybody who displays that or has a frame affixed that covers up any of the wording, or at least maybe just half the wording, is subject to being pulled over and a $2,500 fine and a 6 months jail sentence.
According to the statute, yes.
And is that true if somewhere else on the plate, the identifier Kansas is clearly legible? Is that still true?
I go back to, it is the ability to identify the plate as a whole, and is it clear? And that's the modification to the word legible. So if it's clear that it is a Kansas plate to the officer, then it's legal. But if it is not clear, then it is not a legal display of a plate.
So if he can read that as he approaches the car, then he can read Kansas on that little registration sticker. He has to stop and turn around, right?
So this will be, that would be going back to the other argument that the Court of Appeals did not get to, and which didn't really come up in the petition, which is the question of, does it have to be from a safe driving distance? And that is a secondary question that the state had raised below, but it just was never decided on by the Court of Appeals. Our position is it has to be from a safe driving distance, because otherwise the purpose of the statute is completely undone. But
let me take you back to your previous argument, though, before you get into that. Am I understanding your position to be that my favorite license plate is the K-State alumni plate, okay? And if mud obscures the power cat on the bottom left, that is a basis for law enforcement to detain individuals?
it goes back, again,
I mean, anybody that obscures the power cat maybe should be punished, but not necessarily talking about this statute.
correct. What I go back to is, can the officer identify the car by the plate? The plate is identification for the car. It is a way for a person who is behind a car to know who is driving, well, who owns the car, who has registered the car. That is the purpose of the plate. If you can identify that the plate, what the plate is, then the fact that the power cat is obscured doesn't matter. But if it's a generic silver plate, and the only thing that identifies it by what it is the power cat symbol, and that's obscured, then no, the plate is not clearly legible. If that's the only thing that the officer has to go off of is a symbol that's not visible, then the plate is not visible.
You have to admit, though, in Justice Wall's example, because that's where I was going to come from, you have to admit the statute, as written, makes it a crime if just the power cap is obscured, and you can see Kansas, you can see the numbers on there, you can see everything. You just can't tell whether Justice Wall likes Wildcats or Jayhawks. This statute says if the plate isn't clearly legible, it's a crime. It doesn't say any of that other stuff that you want to add to the statute. And that's the problem I'm having
and again,
with it.
Justice Biles, I would just disagree that I'm adding anything to the statute. The definition that I'm working off of is the Court of Appeals definitions.
I don't care about that. We're interpreting a statute. And where I went to law school, Professor Cannon said when you're interpreting a statute, you read the statute all the way to the period.
Right.
And that's what we're doing. I just want to stick to the statute and the language there. And under Justice Wall's example, he's a criminal. Because his power cap's obscured.
If Kansas...
And I would throw him in jail for a long time just for that. But I'm back to the statute, so...
We would be a split court on that, though.
Well, I went to William Jewell College, so I don't have a dog in this hunt. But again, the statute requires the plate to be clearly legible.
And the power cap's part of the plate. That's the point here.
Well,
just plain language.
Right, but it's that it's legible, that it is able to be, and legible means, the dictionary definition just means able to be read or easily able to be read or deciphered.
But I can't tell whether he's a Jayhawk or a power cat guy.
But that doesn't...
And that's part of the plate.
But that doesn't change that the plate can be deciphered. The plate can be deciphered so long as it can identify him, and if it identifies, or sorry, not even him, the car, if it identifies the car as being having a Kansas plate with a number, that is decipherable. The rest doesn't matter.
And the statute doesn't say that, does it?
No, I believe the statute does say that.
There are some words that we haven't talked about, and that is the clearly legible is in a phrase, in a condition to be clearly legible. That doesn't say anything about distance, it doesn't say about purpose, it doesn't say anything about even at the moment being clearly legible, but just in a condition that it could be clearly legible, doesn't it? Does that change that perspective?
And this goes back again to the arguments we made initially about whether there is a history of interpretation specifically on the federal side, which has taken the same language, has taken our statute, and has said it's from a safe driving distance. That was not reached by the Court of Appeals, but it's our argument that that's the only thing that makes sense, because to not read that into the statute is to make the statute completely meaningless.
And I take it from that you would disagree with your opposing counsel's argument that we could apply an objective test to determine clearly legible? Because it would have to be the subjective ability of that officer to read it from a distance. Would that be true?
I think a safe driving distance, if it's visible from or legible from a safe driving distance, that would be somewhere, that is more objective. It is difficult because you're talking, we don't see things statically on the road, as Mr. Shire said. There's different conditions that might change things, but the plate itself has to be
In a condition to be clearly
right, in a condition to be clearly legible. So that would tend to mean to me that it's just when someone is driving behind you and not tailgating you, can you identify it? And the example I gave in the original brief was the purpose of the statute is that we all, not just officers, not just police officers, but we all have a tool to identify who might be in another car, who has registered that vehicle. And there are abundance of reasons to do that. And it can be something like we observe someone driving erratically, and we want to make sure that if we report it, the police could find that vehicle and identify it out of every other vehicle. There are reasons why the statute requires that a license plate be clearly legible and clearly visible to other people on the road. And if it is not required that that be from some sort of safe driving distance, then that statute has no meaning, because it would allow for someone to obscure their license plate to the extent that it could only be read when you literally walked up to it and were inches away. For instance, if someone has a tinted, they sell these, they are, in my opinion, not legal, maybe that'll be different. There are tinted license plate covers that make it impossible to read the license plate until you are literally standing with your eyes to it.
You point to federal law for us to apply some of that. But this court's rules are that when we interpret a statute, we look at the words of the statute and only get to intent, or look at adding concepts like reasonable driving distance if the language of the statute is ambiguous. So under our rules, why do you feel the statute is ambiguous?
Well, I tend to side with the Court of Appeals.
I'm sorry.
I tend to side with the Court of Appeals that the language wasn't ambiguous, and the thing to...
Then how under our case law do we look at intent?
Right.
Which you have argued. The intent to be able to basically run the tag.
Right, but also, it's not the license plate was legible. The language of the statute is the license plate was clearly legible, and if you read it in a way that there is no requirement that a reasonable person can read that statute from a safe driving distance, then the word clearly has no purpose there. For something to be clearly legible, it has to be easy to read. And I guess what I read is that if you were to read the statute any other way, you're essentially just reading the word clearly out of the statute. And that word is there and modifies legible, and that has to serve a purpose.
How could a decal, the registration decal, that's, I think, 1 inch by 1.5 inches, maybe, traveling on interstate at 75 miles an hour, driving at a safe driving distance, what is that, like 100 yards away? And nobody could read that, could they? Or I couldn't read it, I should say, but maybe my vision needs checked.
I tend to be able to read them, but I have the privilege of 20/15 vision. So, but again,
you can read the license plate number, the date.
No, I can just the Jan, Feb, June, not the individual codes. No, I cannot read the individual codes. And again, I'm not sure if the registration sticker is governed by a separate statute that requires something specific to it and how it is displayed on your plate.
Are there other questions? Okay, thank you, counsel. You reserve 3 minutes.
Thank you, Your Honor. And I guess I just keep coming back to the same two things, the same two questions. Is it visible and is it legible? Here we've got a picture of the plate. We've got a body cam, which I encourage you to watch again, of the officer calling in that plate from his squad car, including the state name. When he goes to make contact with Brian, he does not stop to look at that plate. He walks right on by after having called it in as an Illinois plate and starts this traffic seizure. Under those facts, yes, this plate is visible. Yes, this plate is legible, and that demands suppression.
What is the point of the word clearly then?
The point of the word clearly, it needs to be easily readable, but again, there's only one thing that the bottom half of the word Illinois can be. And the fact that this officer called it in from his squad car shows that he knew that as well. Looking at that picture, it clearly has to be Illinois. There's nothing else that this plate could say.
Is there any good faith exception that could be applied here that would save the search or the fruits of the crime that was subsequently found?
No, Your Honor. First of all, the state never invoked or tried to invoke that exception below, and that is their burden if they're going to invoke an exception. And second, typically when we're talking about a good faith exception, we're talking about a change in the law. This was not a change in the law. This was just...
Is it a reasonable interpretation of the law that Officer Rose had, or that he believed that he was in violation of law by having a partially obscured state name and had a basis for that?
No, I don't believe there's any Kansas case that says that. There is an unpublished Kansas case, but applying some of the federal standards that this court has talked about, and which frankly don't match the plain language of the statute, but I am not aware of any Kansas case that he could have been relying on.
You don't think an unpublished Court of Appeals decision can give an officer good faith? Is that your argument?
It's not binding precedent.
It's not binding on courts or on higher courts, or I guess on other panels of the Court of Appeals. But it does seem to me, I mean, for you to win this case, we're going to have to overrule those decisions. There will no longer be good law. I mean, I guess we could...
That's true, Your Honor. And I guess, to be perfectly honest, I don't know, because I haven't researched that question, because this is the first time that the good faith exception has come up. And again, I'll fall back on the state needs to bring that up in district court if they want to rely on it now. Unless this court has further questions, I will close by asking this court to reverse and to remand with instructions to suppress the fruit of this unlawful seizure. Thank you.
Thank you. Thank you to both counsel for your arguments this evening. The court will take this matter under advisement. So to explain to everyone what I mean by that when I say we will take it under advisement, the court will actually meet tomorrow to discuss this case. We will perhaps decide on an outcome. Sometimes it may take more than one coming together and more discussion than that for us to reach that decision. Once we have that preliminary decision made, one of the 7 of us will be assigned to write a draft decision for the other justices to review. It's a little bit like having your worst nightmare of an English teacher grading your paper, because we all will comment and mark it up and have our input into that as we come together to reach a decision. We may not all agree, in which case some of us may write separately in either a concurring opinion or a dissenting opinion. A concurring opinion is a situation in which the person who is concurring agrees with the outcome, and that is whether we affirm or reverse the lower courts, but may not agree with the reasoning that gets to that outcome. A dissenting opinion is one where we disagree with that outcome. So those, once all of those decisions are finalized, we will file this decision or decisions with the clerk of the appellate court. As counsel referenced, that usually happens on a Friday morning. When that does happen, we do 2 things. One, we release a press release that lets everybody know that that decision has been decided. And second, we will post the written decisions on our KS Court's website. So one thing that sets the courts apart from our other sister branches of government is that when we make a decision, we are very transparent about the reasons for our decision. You're able to read the entire reasoning of why we are doing something. The executive branch may sometimes explain, but they don't have to, and they often don't. The legislator may decide to go to the well and explain his or her vote, but more often they never explain on the record why they vote in a particular way. But we and the lower courts all make that very clear and in writing. So at kscourts.org, you can find any decision of this court, and also you can find archives of oral arguments like this. The videos are linked to those decisions. So if you read a decision you're interested in, you can go back and watch the argument on that as well. So thank you for your attention tonight. It's been our pleasure to be in Louisville and to be here, and we again appreciate your coming out this evening. We're looking forward in a few minutes. We will join you in the area, I think the school calls the Main Street, the Commons type of area outside the auditorium. Again, thank you and good evening.
All right.